Many of you could probably relate to this scenario. You're attempting to get Service Connect for something. You're denied Service Connection, so you go get an independent medical opinion or Nexus Letter. You submit it, and you get denied again. The VA didn't even look at the Nexus Letter, or they overdeveloped the case, and they want to send you to another exam. Welcome to VA Made Easy. I'm VA-accredited attorney and U.S. Army combat veteran Ed Farmer. Today, we're going to discuss competing medical nexus opinions, the benefit of the doubt rule, and what you could do at the regional office to help grant these claims. If you've been denied your claim, I provide zealous advocacy. I'll prep you for your CMP exams. I'll help you get medical nexus opinions. I'll help you get buddy statements. I offer free consultations at vetlawoffice.com. But for now, let's get into it. How frustrating is this? You get denied service connection. You go out and get your independent medical opinion. You go out and get your Nexus Letter. The VA just ignores it. They don't give it any consideration, or they start to overdevelop the case. They want tiebreaker exams. They want confirmation exams. What can you do to get the VA to consider your independent medical opinion and grant a claim? All right, so your best bet at getting this resolved is to do a higher level review. So if you had a denial within the past 1 year, then you could file a higher level review. Now remember, you can't file a higher level review on a higher level review. So if the last decision was a result of a higher level review, you probably can't file another one. Also, if you need new evidence, a higher level review is not going to be a good option for you. You're going to want to do a supplemental appeal. But if you had a denial within that 1 year and you didn't do a higher level review last time, then a higher level review is probably going to be your best course of action here. So if you do a higher level review, something you got to consider is, do you want the informal conference? So an informal conference gives you the opportunity to speak to the higher level review or decision review officer on the phone and point out what you think the issues of fact or the issues of law are. So remember, you're not giving testimony here. You're not submitting new evidence. These are arguments of why the VA got the last decision wrong. I've greatly reduced the amount of informal conferences I do because as a lawyer, there's just been a waste of time. So I think they've either promoted a bunch of people to the DRL higher level review position, or they've hired inexperienced people in that role because they don't seem to understand basic VA rules and regulations, or they haven't reviewed the file, so they're unfamiliar with what the issues or facts of the case even are. The point of the higher level review informal conference is to have a productive conversation about what the issues are, but some of these people haven't even taken a look at the file. Some of them will say, well, I'm supposed to review it de novo, so I don't want to get tainted by the last adjudicator's decision. Oh, come on, cut me a break. That is just laziness right there. Many times, the higher level reviewer doesn't say anything. I don't even know if they're taking notes. They put a report in the file after our conversation about what was discussed, and most of my points don't end up in that report. So what can you do if you don't want the informal conference? Well, you could submit a written argument to them. Just write down what you think the issues, why they got it wrong in a written argument. And many times a written argument is the best option because then it will preserve those issues on appeal. If you get denied after a higher level reviewer, then you can point out, hey, I pointed out these issues before, nobody addressed them, nobody fixed them. All right, so let's say you are going to do the higher level review. What sort of arguments are you going to want to make? So in order to know what type of arguments you're going to make, you have to understand the VA's benefit of the doubt rule. What the VA's benefit of the doubt rule says is if the negative evidence is an approximate balance to the positive evidence, then the benefit of the doubt goes to the veteran and the veteran wins. Now, the key phrase here is approximate balance. Now, I know a lot of VA representatives and attorneys say that the standard of proof in VA cases is 50-50, and that's not quite accurate. Approximate balance means nearly equal. So if the positive evidence is 49%, then in negative evidence is 51%, I would say that's nearly equal and the benefit of the doubt rule still applies. What you're trying to do during this higher level review process, you want to tip those scales as much in favor of the positive evidence as possible. I would start with looking at their C&P exam. Did the examiner make a mistaken fact? Maybe he said you didn't get hurt in service, but there's service treatment records showing you got hurt. We know that they didn't consider the buddy statements. That's another reason to find their opinion less probative. And they certainly didn't consider the independent medical opinion you submitted. All these things start to tip the balance in favor of you. So get a copy of that exam and start looking at issues. And don't assume that your Nexus opinion is all that either. You can't start poking holes in the VA's opinion if your house isn't in order. I've seen a lot of these opinions coming out of these medical Nexus mills, and they are trash. It is just straight garbage coming out of there. So be careful. Take a look at what you're actually submitting to the VA. Sometimes I've seen them argue evidence that's not actually in the file. They don't give a very good rationale. There's copy and paste jobs. One time I saw another veteran's name in an independent medical opinion. Review your independent medical opinion. Many of these companies will provide rebuttals if you need to make changes. All right, so you want to tip the balance of evidence in your favor as much as possible and argue that you win under the benefit of the doubt rule. The last thing you want to do, and I would say you would prefer a denial over this other option, is them to find a duty to assist there. If the decision review officer or higher level reviewer starts talking about duty to assist there, I would start pushing back hard. So they seem to think, one, that they need tiebreaker exams because there's two conflicting medical opinions. They need a third one to break the tie. No, there's no freaking such thing. Or they want a confirmation exam. They want a C&P examiner to read what your independent medical opinion says and confirm whether it's true or not. That's also not a thing. They're supposed to make a decision based on the medical evidence that's in the record. If that evidence is adequate, they need to make a decision on it. So if they start talking about duty to assist there, I would ask them straight out, what's wrong with my independent medical opinion? Now, half of these DROs, their chin's going to hit the desk when you ask them that. The other ones hadn't reviewed the file, so they're going to have zero clue what's wrong with it. All they know is they're supposed to find a way to deny this or send it back and not grant it. Force them to take a look at your independent medical opinion and not do a duty to assist there. If they want to go through your independent medical opinion and deny it and say, well, it's not probative for X, Y, and Z, then have them do that. And that rarely happens. All right. So if they won't grant and they're just going to keep you on this hamster wheel of exams, you may want to consider going to the Board of Veterans Appeals. My firm has a lot of success at the Board of Veterans Appeals in these cases where there's two competing medical opinions. The board will grant in these cases. If your independent medical opinion is sound and the evidence in the file backs up what the examiner is saying, there's a very, very good chance that the board will grant. Yeah, I know it takes 4 years. I know it does. It seems to be getting a little bit quicker. But, I mean, what are you going to do? Waste your time at the regional office with these bozos who won't even take a look at the independent medical opinion? If you don't get anywhere at the higher level reviewer, speak to a accredited representative about seriously appealing to the Board of Veterans Appeals. That does it, guys. Keep liking, keep sharing, keep subscribing. And as always, you have the power to change your VA claim.